The court session on June 24, 2025, resumed after being adjourned the previous day, June 23, 2025, due to incomplete proceedings related to Simon Ekpa's ongoing trial and bail application. Simon Ekpa's lawyer had earlier submitted a bail application, but the prosecuting lawyer insisted on very strict bail conditions, including that Simon Ekpa must surrender all his digital devices, phones, laptops, tablets, to the National Bureau of Investigation (NBI). The judge reopened the session after a short recess, acknowledging both legal teams and emphasizing the principles of fairness and due process, then allowed the prosecuting lawyer to present an NBI officer to support the condition of seizing Simon Ekpa's devices. The NBI officer testified that the devices could contain evidence such as messages, emails, and metadata relevant to the case, and that their forensic imaging was necessary to preserve potential digital evidence and avoid tampering or loss. Simon Ekpa's lawyer cross-examined the NBI officer, exposing that the officer had no existing court order to search the devices and was relying on consent through bail negotiations rather than legal warrants. The lawyer challenged the officer's argument as speculative, insisting that the request violated Simon Ekpa's constitutional rights since he had not been convicted, and that digital devices contain sensitive personal and legal information. The cross-examination revealed that the NBI was possibly using the bail hearing to explore new charges or expand the current investigation by gaining access to Simon Ekpa's personal data under pressure. Simon Ekpa's lawyer strongly argued that tying bail to surrendering private devices was unlawful, likening it to coercion, and urged the judge to reject the request, stating that bail should focus on flight risk or danger to the public, not evidence gathering. The court allowed a human rights activist and lawyer to speak, who reinforced Simon Ekpa's defense by emphasizing that the state cannot violate an unconvicted individual's rights in the name of investigation, and that such practices set a dangerous precedent. The overall atmosphere in the courtroom favored Simon Ekpa's legal team, with widespread support for their stance on protecting constitutional rights and resisting what appeared to be an overreach by the prosecution, leading to jubilation among supporters in the court. A major courtroom debate unfolded over whether Simon Ekpa's electronic devices, phones and laptops should be submitted as a bail condition, with the prosecution claiming national security urgency while the defense insisted on legal due process. A human rights activist, who is also a legal practitioner, strongly opposed the idea of unconditional access to Simon Ekpa's digital devices, arguing it would set a dangerous precedent and violate his constitutional rights without proper legal oversight. During cross-examination, the prosecution acknowledged the devices might contain relevant evidence, but insisted that immediate access was needed to prevent data loss, claiming that encryption or deletion could occur at any moment. The activists suggested a lawful compromise: let the court or prison authorities securely hold the devices without granting any party access until a formal legal application for review is submitted and approved. The prosecution rejected the idea of simple custody, arguing it fails to address the urgency of preserving volatile digital data, and emphasized that their request is not for unfettered access, but for supervised forensic examination. The presiding judge acknowledged the strong arguments from both sides and criticized the prosecution for waiting too long to seek access to Simon Ekpa's devices, implying the authorities had adequate time during his custody to investigate. Rather than forcing Simon Ekpa to hand over his devices immediately, the judge asked Simon Ekpa to personally explain the kind of data stored on his devices and allowed him time to compile a full list to be presented at the next hearing. Seaman Ekpa told the court that his devices contain personal communications, data from Nigeria, political documents, and information related to his work as a Finnish politician, and requested more time to organize and summarize the content. The judge ruled that Seaman Ekpa would be given until the next court session to present a detailed summary of his digital data, after which a decision will be made about whether or not to hand the devices to the NBI. Both the defense and prosecution agreed with the judge's proposal, setting the stage for a critical follow-up hearing, where Seaman Ekpa's explanation could determine the fate of his bail and the future course of the trial. On the morning of June 24, 2025, the atmosphere in the Finnish courtroom was heavy with anticipation, tension, and cautious hope. The previous day, June 23, 2025, had ended without a final decision regarding the bail application submitted on behalf of Seaman Njoku Ekpa. Seaman Njoku Ekpa, who has become a highly controversial figure in both Finnish and Nigerian political discussions, stood at the center of this unfolding legal battle, facing multiple allegations connected to broadcasts and calls made from Finnish soil that the Nigerian government claims incited civil disobedience and unrest. But what made this day in court particularly explosive was not only the legal questions around his bail, but the fierce debate about a highly controversial request made by the prosecution that Seaman Njoku Ekpa must surrender all of his digital devices, phones, laptops, tablets, as a mandatory condition for bail. This demand set the stage for a courtroom confrontation that would test the boundaries of constitutional rights, legal fairness, and the integrity of Finland's justice system. As the court resumed on June 24th, the presiding judge entered the courtroom, and silence immediately fell. Seaman Njoku Ekpa sat beside his lawyer, whose name was publicly identified as Carl Gustaf Kalgmer, a well-known defense attorney with a deep understanding of both Finnish law and international human rights. Seaman Njoku Ekpa's face bore the composure of a man who had come to terms with the political weight he was carrying, both as a defendant and as the leader of a controversial movement, the Biafran liberation campaign that he has directed from exile. The judge, in his opening statement, reminded both the prosecution and the defense that justice must not only be done, but must be seen to be done. He stressed that fairness, balance, and respect for human dignity would guide his decisions. Then he turned the floor over to the prosecution to present their reasoning behind the request to make the surrender of Seaman Njoku Ekpa's digital devices a condition for his temporary release. The prosecuting attorney stood and walked to the center of the courtroom, accompanied by an officer from the National Bureau of Investigation, the Finnish federal agency responsible for major criminal investigations. The prosecution's argument was straightforward, but deeply unsettling to many observers in the room. According to them, Seaman Njoku Ekpa's electronic devices likely held critical evidence, files, emails, messages, and encrypted communications that could either strengthen or clarify the case. They claimed that due to the nature of digital data, delays could result in the loss or corruption of evidence. They further alleged that Seaman Njoku Ekpa had access to advanced technology and encryption tools, which could allow him to delete or lock sensitive content at any time. The National Bureau of Investigation officer gave testimony, stating that the agency urgently needed access to the devices for forensic imaging and analysis. He explained that digital forensics must be conducted as soon as possible to preserve metadata, timestamps, and other volatile digital footprints. The officer admitted, however, under cross-examination, that the National Bureau of Investigation did not currently have any warrant or court order allowing them to search or seize the devices. Instead, they hoped to gain access through a back door by tying this demand to Simon Nyoku Ekpa's bail. Carl Gustav Kalgmer, representing Simon Nyoku Ekpa, stood calmly and began his cross-examination. With a measured voice and piercing logic, he asked the officer one critical question after another. Did the National Bureau of Investigation have legal grounds to confiscate personal property without a search warrant? Was there any formal request from the Nigerian government asking for these devices? Had Simon Nyoku Ekpa been convicted of a crime? Had he resisted any lawful investigations in the past? The answers were, for the most part, no. Then, Carl Gustav Kalgmer turned to the judge and addressed the court. He made it clear that what the prosecution was requesting was not simply about bail, but about setting a dangerous legal precedent, one where a person who had not yet been convicted could be forced to surrender his personal, private, and possibly legally protected digital life in order to secure temporary freedom. He argued that such coercion went against the very heart of Finland's democratic and constitutional values. He painted a vivid picture of the implications. What if this happened to another Finnish citizen tomorrow? What if authorities could hold bail as leverage to extract information, force compliance, or weaken someone's defense strategy? This, he said, was not justice. It was a form of digital blackmail, masked under the pretense of due process. The courtroom was riveted. Observers, journalists, and even legal analysts present in the gallery sat in stunned silence. The stakes had suddenly become larger than just the freedom of one man. The conversation had shifted toward the future of digital privacy in a legal world that was still learning how to balance security concerns with constitutional freedoms. Then something unexpected happened. The judge called upon a third-party observer who had been sitting silently in the room, a well-known Finnish human rights activist and practicing lawyer whose name was Maria Taavitsainen. She had been invited by the court to serve as an impartial voice. Given the international attention this case had attracted, Maria Taavitsainen took the floor and spoke with conviction and grace. She said that while the prosecution may have valid reasons to believe that the devices might hold useful evidence, bypassing the legal process by attaching device surrender to bail was an abuse of power. She reminded the court that bail is a legal right, not a favor, and that it should focus solely on whether the accused is likely to flee or pose a threat to society. Investigative needs, she said, must be pursued through the proper legal channels by applying for search warrants and presenting probable cause. She warned the court that allowing this kind of maneuver would open the door to future abuses, not just in Finland, but in other democratic countries that watch and learn from its legal system. Her voice carried passion, and her arguments were clear. The room erupted into soft applause, not formal or allowed in a courtroom, but so spontaneous that the judge did not stop it. Even the guards at the door appeared momentarily moved. The prosecuting lawyer tried to push back. He argued that the urgency of preserving evidence could not be overstated, and that the suggestion by Maria Taavitsainen to simply place the devices in court custody without accessing them immediately would not be enough. He warned that delays could allow for digital self-destruction protocols to kick in, encryption tools that auto-wipe data if not accessed within a specific time frame. Carl Gustav Kalgmer responded with clarity. He offered a practical solution. If there was concern about data loss, then let the devices be held securely in a sealed evidence locker under court authority without access by either party, until the prosecution properly submitted an application for access backed by evidence, legal reasoning, and judicial approval. It was a reasonable offer, one that upheld both the legal integrity of the case and the individual rights of Simon Njoku Ekpa. The judge paused. He seemed to weigh both sides with care and seriousness. His eyes scanned the room, then finally rested on Simon Njoku Ekpa. The judge, instead of making an immediate ruling on whether the devices should be surrendered, asked Simon Njoku Ekpa to stand and speak for himself. The courtroom turned quiet again as Simon Njoku Ekpa, a former Nigerian soldier and now a self-declared Biafran political leader, rose and walked to the center. His voice was firm but respectful. Simon Njoku Ekpa told the court that his devices contained not just personal data, but communications with political figures, sensitive documents from his work as a Finnish politician, and private information about his family, including his children's medical records. He explained that the devices also held files connected to the Biafran movement, some of which were protected under Finnish political privacy laws. He was not against legal review, he said, but it must be done with due process and not forced through coercion disguised as a bail condition. Simon Njoku Ekpa asked the court for time to compile a full list and summary of the types of information stored on each device, so that a fair and balanced decision could be made. The judge listened carefully, nodded, and then made his ruling. He declared that Simon Njoku Ekpa would not be forced to surrender his devices immediately. Instead, he would be given time until the next hearing to submit a complete written summary of all the digital data on each device. After reviewing the summary, the court would decide whether a full or partial forensic examination would be allowed, and under what legal terms. The courtroom responded to this announcement with a quiet but unmistakable wave of emotion. Supporters of Simon Njoku Ekpa smiled. Some clasped their hands in silent thanks, and others quietly whispered prayers. Though this was not yet a final victory, it felt like a moral and legal breakthrough. It was a clear message to the world that Finnish justice could not be manipulated, and that even in cases involving complex digital evidence, the law must be respected. The ruling, though temporary, meant that Simon Njoku Ekpa could now continue to fight his legal battle without being forced to give up his constitutional rights as a human being and as a Finnish resident. Outside the courtroom, crowds gathered. News of the decision had spread like wildfire through Finnish, Nigerian, and international media outlets. Biafran supporters, wrapped in the traditional red, black, and green flags of their movement, stood under the grey Helsinki sky, singing songs of victory and justice. Some held signs saying, "Freedom is a right, not a bargain," and "Human rights are non-negotiable." Among them were members of the African community in Finland, Finnish human rights groups, political sympathizers, and even some European activists who had come from neighboring countries to show solidarity. They did not see Simon Njoku Ekpa merely as a man on trial, but as a symbol of resistance against state overreach in the age of surveillance and digital warfare. Meanwhile, legal analysts across the country began discussing the broader implications. Would this case now serve as a legal blueprint for how Finnish courts handle digital evidence in future criminal cases? Could this ruling influence European Union privacy laws? And most importantly, would Simon Njoku Ekpa's case become a watershed moment in the ongoing debate about the balance between national security and individual freedoms? As the sun began to set over Helsinki, the echoes of that day in court continued to ring in the ears of those who witnessed it. Simon Njoku Ekpa had not only stood firm, but he had done so through the power of legal argument, constitutional rights, and moral conviction. It was a day of jubilation, yes, but also a reminder that justice is not given, it is defended. And on June 24, 2025, in that Finnish courtroom, justice found its voice. It spoke not through force but through law, not through fear but through reason. And for that moment, it belonged to everyone who still believes that the courtroom is a sanctuary of truth, not a battlefield of manipulation. More was yet to come. The next court session would bring further debate, more evidence and more questions. But for now, Simon Nyoku Ekpa had won another round, not just for himself, but for anyone who has ever had to defend their privacy, their dignity, and their rights in the face of overwhelming power. As the crowd of supporters spilled out of the Helsinki courthouse, their cheers slowly gave way to emotional conversations in small groups. Some had tears in their eyes. Others held up their smartphones to record the moment for loved ones back home in Nigeria. It wasn't just a legal victory, it was a deeply emotional moment for many who had spent years believing that their voices were too far from power to ever be heard. Yet today, in a European court, those voices, through Simon Nyoku Ekpa, were not only heard, they were defended. Simon Nyoku Ekpa was quietly escorted out of the courtroom through a side exit, away from the media frenzy building outside the main entrance. His legal team had requested privacy to avoid chaos, and the court had complied. But even as he stepped away from the public eye, his influence surged. His supporters were already spreading word of the victory across social media platforms. Videos from the courtroom and outside were going viral within hours. Simon Nyoku Ekpa's lawyer, Carl Gustav Kalgmer, gave a brief statement to the media outside the courthouse. Standing before a line of microphones with cameras pointed at him from all angles, he remained composed yet passionate. He thanked the Finnish judiciary for their impartiality and acknowledged the courage of the presiding judge, who had chosen legal principles over pressure. He stated that their team was preparing the detailed digital summary as ordered by the court and emphasized that Simon Nyoku Ekpa was committed to full legal transparency, so long as his constitutional rights were protected. Then he walked away, refusing to take more questions, signaling that the case was far from over. That same evening, inside a modest apartment in downtown Helsinki, where Simon Nyoku Ekpa was being temporarily held under private monitoring, a flurry of activity took place. His legal aides were sorting through devices, carefully cataloguing, noting and summarizing each item, application, folder and file. Simon Nyoku Ekpa, though visibly tired, was fully involved in the process. He insisted that each item listed must be properly explained so that the court could see that these were not tools of crime but part of his life's work, his political mission, his advocacy, and his correspondence with international supporters of Biafran independence. His team drafted the beginning of the report that would be submitted at the next hearing. It included personal data categories, political correspondence logs, media recordings, Biafran government in exile documents, encrypted archives of meetings with Finnish politicians, and messages from international humanitarian groups concerned about the Nigerian government's crackdown on separatists. Meanwhile, back in Nigeria, the reaction from government officials was intense. Inside the presidential villa in Abuja, Nigeria's capital city, top security officials gathered in an emergency closed-door meeting chaired by the National Security Advisor. There was concern that Finland's continued protection of Simon Nyoku Ekpa's rights and the mounting public sympathy for him could embolden separatist groups back home, especially the Biafran Liberation Army factions that had recently resurfaced in southeastern Nigeria. The Nigerian Minister of Justice reportedly called for Finland to do more to cooperate in countering transnational incitement. Meanwhile, the Nigerian ambassador to Finland prepared a fresh diplomatic protest letter, accusing the Finnish court of undermining Nigeria's national security. But insiders close to the Finnish government revealed that such pressure was unlikely to influence the outcome of judicial decisions. In Finland, the courts were fiercely independent. Observers interpreted this as subtle diplomatic support for the Finnish court's handling of the matter. This is the end of our news update. Please click the icon on the top right corner of your screen to watch my next video. You will enjoy it. I will see you again in my next update. Enjoy the rest of your day. Goodbye for now.